Okay, it's 4 o'clock. Good afternoon, everybody. It's a pleasure to be. I'm Ugo Pagallo, and I'm moderating this panel on the underuse of personal data, its opportunity costs, and EU policies. Referring to the underuse of personal data, we're referring to the bad reasons why we are not properly using personal and non-personal data. A good example is given by the reuse of health data in the healthcare sector, in which, on the one hand, the GDPR, as you know, has triggered the fragmentation of the system, and on the other hand, we are missing opportunities to exploit a treasure in order to improve, in light of my previous example, healthcare services, medical research, so on and so forth. Of course, we are not breaking news. The EU institutions do know that we have this problem. It's not only a European problem. Time and again, other international organizations have stressed this issue. So the overall idea of this panel is to examine the reasons why we have this problem. In other words, what are the drivers of this underuse? Second, what are the EU policies? Another example is given by the Data Governance Act, but there are several further European initiatives. And finally, however, why most of those initiatives have fallen short in dealing with the phenomenon of the underuse of personal and complementarily non-personal data. So let me introduce you the speakers according to the order of their presentation. And so we have the pleasure to have Bárbara da Rosa Lazarotto from the Free University of Brussels. Then the floor will be for Antonius Bouchagiar. Try to pronounce it in from the European Commission's Legal Services. Then Aurélie Pauls, Data Protection Officer and founder of the Aurélie Pauls and Associates, among other things. And last but not least, Alberto Di Felice from Digital Europe. So let's start with Bárbara on this specific issue, namely the underuse of personal data and the EU policies. Thank you.
Thank you, Ugo, and thank you for inviting me for this panel. So I think the first point that we need to talk about when you're talking about underuse of personal data is that this fight for control over data has been a narrative of the EU legal strategy for a long time. I believe that the GDPR is an example of that. People believe that the GDPR is to avoid the flow of personal data, but it's not that. It's like the legal and the lawful flow of personal data. So since the 2018 of the GDPR until now, with the Data Act, with the Data Governance Act, the idea is to put control, but to use data. So why the underuse of personal data? Well, there are many reasons. For example, data monopolies. I believe that the industry has been developed and designed in a way that we have major players that are hoarding data, and the ones that are the data users, let's say, the owners, I don't think this term is correct, but anyway, do not use and do not have the benefits of of the use of personal data. So that's a problem. I also believe that now we are facing a new era of EU policies. I believe the Data Act and Data Governance Act is a very a good promise with the data intermediaries, data altruism. I believe that we have a good future ahead of us for the use to tackle the underuse of personal data. But also we have to keep in mind that we have problems also with unleashed sharing of personal data, so we have to take that into considerations, which brings new good and new interesting discussions to the table, like how can we protect and kind of control the sharing of personal data so we can use it for the benefit of everyone at the same time that we protect individuals. I think there are many ideas that I saw even in CPDP today, and I think we can discuss that during this panel. Yeah.
Thank you very much, Bárbara. And good point, that is here, one of the aims of this panel is to discuss a problem that is often overlooked, although it's as important as tackling possible potential misuses of personal data. And okay, now let's go on with Antonius. Please, the floor is yours.
Thank you very much, Ugo, and thank you for inviting me. It's a pleasure to be here. I'm a member of the Legal Service of the European Commission, and of course I speak in my personal capacity. I have some slides, and don't worry, it's not too much text. It's just in order to structure a bit the discussion, because I will refer to some provisions and some conditions of some laws, some provisions of the GDPR, and it's useful always when we look at what we are talking about instead of just orally describing it. So there is a lot of discussion about regulating artificial intelligence. There are proposals pending of legislation in that regard, but there are also rules that we already have on regulating artificial intelligence, at least to the extent that they consist in automated decision-making systems, to the extent that artificial intelligence can be involved in decision-making. And what decision-making is a big discussion that would be useful to see under the GDPR. So I would like to speak about provisions that we already have in place in that regard. Okay, it works, great. And one such provision, a main one in the GDPR, is Article 22. And there we do have in paragraph 1 a prohibition of principle, so it's subject to exceptions in paragraph 2, but there is a prohibition of principle in automated decision making. I have put different colors, not just to make it fancy, but mainly in order to highlight the different conditions that I will examine one by one in the next slides. The main gist of this provision is that individuals must not be subject to automated decision-making, meaning decisions that are based solely on automated processing, and profiling can be such an automated processing, decisions are meant as decisions producing legal effects or non-legal effects if they are similarly significant. But let's go one by one to see what this means and what kind of cases it can encompass. And I will give you also some factual background on certain cases that are currently pending before the Court of Justice, and they concern credit score agencies. What are credit score agencies? They are private companies that gather information on creditworthiness of individuals. On every individual they can find in their relevant market where they operate, From any source. It can be from public sources, data on possible insolvency proceedings, for example, or it can be any other data that can come in their hands. They feed it into a system, and then they have a certain algorithm, and it produces a score. For example, this individual has 70% creditworthiness. And they have this score available at the press of a button based on the information that is available, on the personal data that is available of each individual. And their clients are mainly banks, but not only. Banks are interested, of course, to know the creditworthiness of potential persons who go to ask for a loan. And in such a case, they will ask such agencies to produce a score for the specific people. Or they may also be, for example, telecom providers. If you want to enter into a long-term mobile telephony contract, your creditworthiness may be relevant. Or it may be even vendors of appliances who are selling, but they accept payment in installments. Then again, creditworthiness can be relevant. But let's refer to banks for the sake of simplicity as the main client. Now, individuals who are subject to that scoring, they are faced with the following difficulty, practical difficulty, or one could say even lacuna. They don't get a loan, let's say, by the bank. So they go to the bank and they say, why didn't you give me a loan? And the bank says, well, your score was very bad. You got 10% creditworthiness score. I'm just making this up. The individual wants to know more. Why did I get 10%? I pay all my bills. I don't think there is any reason. The bank says, well, I don't make that score. Go to the agency and ask them. They go to the agency and the agency says, well, my client is the bank. I am just... I didn't decide anything on you. The bank decided not to grant you a loan. They decided it based on the score. It's their decision. Go complain with them. So they are faced in this impossible situation that there is a lacuna, and they go to two entities, and everybody puts the blame on the other one. Of course, the idea behind Article 22 is that individuals must not be subject to automated decision-making because there is a suspicion that such decision-making can be not fair in some cases, or it may lead to discrimination. It may reinforce existing stigmas, depending on how the information is fed into the system. So the idea is that there should be human intervention so that the individuals concerned, they can have a reasonable explanation on why a decision was made in their regard, or they may even contest that decision if they can understand why it was taken. Now, let's, with that background in context, let's look whether we have an automated decision-making in such case, and most importantly, who decides, the bank or the agency? The first condition, do we have automated processing, including profiling? Well, profiling we do have. It's defined in the GDPR, Article 4, Paragraph 4, and we can take some elements of that definition that are certainly present here. We have, based on personal data, an evaluation that aims at analyzing or predicting at least the economic situation of the individual, his reliability or her reliability, and the behavior. So these are elements explicitly mentioned as the kind of profiling that can qualify as profiling under the GDPR. So we do have profiling. Then the next condition, do we have legal effects concerning the individual or similarly significantly affecting the individual? Now, we don't yet say who decides, because that's a key question, but in the end of the story, we do have legal effects, because in the end of the story, the individual cannot get a loan from a bank. These seem to be legal effects, because he cannot enter or she cannot enter into a contractual relationship, so it's a denial of entering into a legal relationship. But even if it's seen as a non-legal effect, it is a significant effect to a similar way as a legal effect. The third condition, and here I put the whole sentence for context, but the condition is the word solely, so the decision must be based solely on automated processing, including profiling. Again, we don't see yet who decides, but at the level of the agency at least, we do have an outcome, a score, based solely on automated processing. There is no human, it's at the press of a button. And then let's go to the key condition. Do we have a decision? And most importantly, who decides? Do we have a decision only when the bank decides not to grant a loan? Or do we have a decision already at the previous stage when a score is established? And I think this would depend on the circumstances of each case, and particularly on the decisional process and the impact that the score has on the decision of the bank to grant a loan or not to grant a loan. We can imagine two hypothetical situations. Let's imagine that in a certain market, banks are critically, with humans, checking the score, amongst many other factors, many other pieces of evidence about creditworthiness, and they decide in a critical way to grant or not to grant the loan. I think in such a case, we can say the score didn't already decide, it didn't predetermine the decision of the bank. Let's take another hypothetical situation. Let's take a market where the score predetermines the decision of the bank. It may predetermine it in the sense that the score is too bad. So the market, it's a market practice for all banks that if a score is below a certain threshold, it's not even worth bothering further. We should just reject the loan. Or if we have any human involved, it's not a meaningful involvement. The decision is predetermined. Or it may even be that the loan will be granted, but the range of the interest rate will be predetermined depending on the score. So let's not take for granted that once the loan is granted, it means that there is no predetermination of that decision by the score. Of course, these are different hypothetical situations, and it would depend on the facts on the ground, whether we are in one or the other. It's a bit of a paradox, but we see that the more impactful the score is, so the more successful the agency is in having a score that matters, the more likely they are to incur liability as decision makers. But that's not really a paradox. I think it's normal also in other fields of law. If any of you is familiar with antitrust law, there is a doctrine, a settled case law, that if you are dominant, you have increased responsibility, you have a special responsibility. So you cannot do some things in the market because you are dominant that other companies that are not dominant can do. So it's not nothing strange, but I just note it because it may appear at first face as something strange. Article 22, however, is not the only provision we have in the GDPR on automated decision making. We also have 3 other provisions in the GDPR that concern the individual's right to receive information about the existence of an automated decision making system, and also meaningful information about the logic involved and about the significance and envisaged consequences. Now, sometimes what we see is that the company that is involved, that has such an automated decision-making system, they may raise an objection to providing meaningful information about the logic involved because they claim that intellectual property rights would be revealed, or trade secrets, or the copyright on the software. But one wonders whether it's really necessary, for example, to reveal the algorithm behind a certain automated decision-making system. Would it even be useful for the individual to know the algorithm? Most individuals probably would not even understand what this is about if they get the algorithm. So I would say it's not even intelligible if they get that information. What they should get instead is a simple explanation about the method used for the calculation, an explanation that normal citizens on the street can understand. What are the factors that were taken into account, and what weight is given to each factor in the way that we would discuss it like between us now, not in a technical software way. So if that is what is desired under that requirement, I don't see how IP rights or trade secrets would normally be breached. I would compare it to the leaflet, to the paper that we get inside the medicine when we buy it from the pharmacy. Of course, it has useful information that every consumer can understand about side effects, about the dosage, of course, always in consultation with the instructions of the doctor, but it's understandable generally, most of it. But it doesn't reveal the patent or the chemical formula of the medicine and any trade secrets. That's not the point even of that paper. Similarly here, and even in a simpler way, one would think, that's the idea of getting meaningful information about the logic involved. Now, these issues, they are, I just gave some general questions, of course. They are in cases that are pending. There are 4 cases currently pending before the Court of Justice. On the first 3 of those, we do have an advocate general opinion that you can read already if you want to have further thoughts on that. we don't have a judgment yet. On the fourth one, we don't have a judgment, we don't have an advocate general opinion. But for those of you who are interested in following up further the scope that automated decision-making can reach, you can follow up these cases to start with, and maybe we'll have more to be seen. Thank you very much for your attention.
Thank you very much, Antonios. And well, let's say that we could add a layer of complexity here. That is, in addition to some problems posed by the GDPR, we have, and we're gonna have, tricky issues of coordination among several pieces of the EU legal framework. I'm considering the GDPR vis-a-vis this moving target, which is the Artificial Intelligence Act. Both are have adopted a risk-based approach, but in several cases, it's going to be very hard to coordinate both approaches, even considering scoring, automated decision-making, and the like. But in addition to the complexity of the legal framework, we have to consider further drivers of possible underuse. And I think that Aurelie, because of her experience, can tell us a lot of things about this further set of issues. So please, Aurelie, the floor is yours.
Thank you, Ugo, and let me build also on top of what Bárbara was talking about and Antonios. So I'm not a policymaker, I'm not a lawyer, I'm on the business side acting as a data protection officer for digital platforms mainly, not the big ones, so I don't have the monopolistic issues and things like that. By choice. But I think it's important to understand indeed and to build upon what Bárbara certainly said. And as I work with US-based companies, a lot of them came in 2016, 2017 by saying, oh my God, the GDPR, the Europeans say we can't use data, which was obviously not the case. We're talking about, yes, you can use personal data. We've broadened the scope a bit more of personal data. That's something else. It's not PII. But you need to do this in an accountable way. So lawfulness, thinking about the principles and things like that. And so from that point of view, it took a time, certainly from the enforcement of the GDPR, to make companies understand that there is no prohibition on the uses of personal data, but there are obligations. And this is where the interesting journey starts of also privacy engineering to say, what are these obligations? What are we talking about? What do we need to do with the data to make sure that we go towards, for example, the transparency obligations we see in Article 22, the logic of an algorithm, as everybody likes to talk about artificial intelligence lately. So in that sense, it's important to understand, first of all, that a lot of, I think, privacy lawyers started to look at some form of a checkbox exercise to say, well, okay, so I'm a data controller, you're a data processor, so we need contracts. So let's get contracts. And we're seeing that also, for example, with international data transfers. When Privacy Shield was invalidated, the biggest issue, the biggest challenge in the privacy sphere was, oh, it's not Privacy Shield anymore. We need to sign standard contractual clauses. And then we went to new standard contractual clauses. So these are processes that are put in place, but are certainly put in place mainly by legal departments to create additional paperwork to make sure that certain boxes are checked. And I think it solves for certain issues, but it doesn't solve for the real challenges that we're going to see, certainly with the launch of ChatGPT and things like that, and basically the harms and the issues that the increased use of data, be it personal or not, are going to have in terms of influence on our societies. So misuse or underuse of data, I think, is partially due to these checkbox exercises and also due to the fact that a lot of privacy professionals don't really understand what's going on with the data, understand that there's a lot of fines going on there in Europe. So we're at 1.5 billion, I think, if we start counting up. But that's the important idea is really to start thinking about not just the contractual obligations, but also what it means to actually the data flows. And certainly when we start talking about whether it's data subject rights and Article 22 also, that's coming more and more, thinking and looking inside the data flows to understand what this means. And typically this starts with understanding that, well, if you want to process data, it needs to be lawful. You need to have a lawful purpose for that and define whether you're going to collect that through consent, through contract, through legitimate interest, yes or no. And so the main issues that I see today, certainly looking at the data flows, is that there's a disconnect between those paperwork contracts, those policies we put in front of data subjects, these consent checkboxes that we see, and the actual data flows. Because in the end, what you're seeing is data engineers looking at their cloud-based databases and saying, oh, I have an opportunity here to optimize. I want to do that. Can I do that? And companies need to make sure they have the right processes in place to collaborate internally to decide whether indeed these further uses of data are actually possible. So the thing I have been crying about for years is inside databases that contain personal data, I don't see the lawful basis. I don't know if it's contract, consent, or things like that. There's a disconnect between the systems. I also don't see the purpose. So it's very interesting to talk about purpose limitation as a principle within the GDPR, but when you have savvy data engineers who want to use the data, and you don't want to be the person to say, no, you can't do that, but you need to go back to the contracts, to what you promised to the data subjects to understand whether their new purpose is applicable or not. And then the last point is also, we've been through a free-for-all period, certainly for data engineers. Let's grab everything and see what we want to do with it. I think the hardest thing they need to do is define the purpose for which they want to use the personal data beyond anonymization or pseudonymization or things like that. But these definitions of purpose, why am I collecting this? Why am I processing this? Is this in line with what the data subject imagines? Is something that needs to be increasingly discussed to make sure that we start aligning between the paperwork and the technical systems. So this is what I wanted to bring to the table.
Thank you very much, Aurelie. And well, it's always important to understand the difference between law in the books and law in the making, and how the law is practiced at the end of the day. But let's add a further layer of complexity to our picture. And I know Alberto has a lot of things to tell us about the current EU legal framework concerning, of course, the topic of our panel. Please, Alberto, the floor is yours.
Thank you, Hugo. One of the many things I want to say is that when I got your invitation, very kind invitation for this panel, which I obviously immediately accepted, I was very confused by the title of your proposed panel. And I was thinking to myself, what do you mean the underuse of personal data? So maybe I wasn't following the academic debate as much. I wasn't really seeing how the term underuse was hidden in the new commission's, by now very well-established commission, the data strategy they put in place. Because I think the public narrative is quite the contrary. The public narrative is that it's the Wild West out there, and everybody is using your data, my data, everybody's data for all sorts of purposes. I mean, there are credit agencies out there that are getting data from God knows where and selling it to banks. I mean, this is outrageous. As a matter of fact, if you look at what the Commission has been doing, the data strategy, I think there's the opposite way of looking at it, in the sense that this Commission has started from the premise that forget personal data. Personal data is a thing of the past. Europe sort of lost the game to the US. What we're looking at in terms of the data strategy is non-personal data. So a lot of things that have happened with this commission have been around this myth, if you will, that we will be unleashing the power of non-personal data. And we have a whole host of legislation that tries to do that. There's the Data Governance Act, which plays with personal and non-personal data. And there's the Data Act, which predominantly aims to unleash the power of non-personal data. Those are the two main pieces of legislation. Then there's the e-health, European health data space. There's going to be lots of other proposals in the Green Deal space, in automotive, if we get there, et cetera. And the idea is very much that we're looking at non-personal data. So there's no underuse of personal data, if you will. There's just an underuse of non-personal data. And even when personal data is there, it's not so much about the underuse. It's about the fact that there's this concept that there's only a few people that are using the data, and we need to open it up. And that sounds very noble, sounds very much, you mentioned competition law, and I think there's this construction in the Commission's mind that, take the Data Act, it looks predominantly at manufacturers of IoT devices, and there's all this, non-personal data and machinery, industrial machinery, that it's simply laying there and being used only by the manufacturer, or maybe not even by the manufacturer of that device, and we need to open it up so that other people can look into it and do all wonderful things with it. The only problem when I look at this is that I'm not sure what non-personal data we're talking about. If I look at I go back to the Article 29 Working Party, glorious guidance on the Internet of Things, and all the subsequent guidance that we've seen from the EDPB, there's not a single vertical market in the IoT space where the EDPB is telling us that non-personal data is a thing that can actually exist. We've had lots of discussions with the EDPB, and I think we have very compelling submissions to the EDPB that, for example, will tell you that you can have braking data from a car that is genuinely non-personal. Why? Because it's very rare that the braking patterns of an individual, just those braking patterns from the brakes of a car, unlinked to any other personally identifiable information, will ever allow you to tell that it's you because you like to brake a certain way as opposed to me. And we haven't gotten there. The EDPB never gave us the satisfaction of admitting that it's possible. And right now we're going into all these sort of new frameworks with new rules, with new authorities that are supposed to interpret these rules, while we're still waiting on the final rulings from the court about automated decision-making. And as opposed to making things clearer and letting people have more clarity and more willingness to collaborate, getting real on sharing databases and creating data spaces, I think it's gonna do the opposite. Think of the Data Governance Act, one of my favorite examples these days, because it's a beautiful piece of legislation. Why? Because again, the premise is there's not enough data sharing. There's data lying there somewhere, and it's in silos. We need to create data intermediaries. We need to create data spaces of public-private data, mostly public in the Data Governance Act, and that's going to open it up. And how are we going to do that? Well, of course, the logical way to do that is we'll have the Data Governance Act that sets out 37,000 rules and processes that you need to follow if you want to share data. Now, that doesn't sound like a very compelling way to encourage people to share data. It's very likely that it will do the opposite. People will just look at the Data Governance Act. They'll say, "Gosh, how the hell am I going to come to grips with this? How can I use this?" Data Act is also a bet in a sense, and we're very worried that we had discussions on the previous panel, and you also mentioned, Antonio's, the issues with trade secrets. We're very concerned about those, but that's a separate matter. So I think there's a lot of goodwill. There's a lot of, if you will, industrial policy behind these new choices. But I think there's a lot that is very uncertain, and it's very likely the way at least the way we understand the legal system that's coming up, that it will ultimately not work. And behind this, there's the fundamental fact that I think we're trying to hide from ourselves, that a lot of the underuse that's there is actually not a legal matter. It's not a matter of lack of clarity around the conditions, even though in some sectors, say healthcare, for example, that has been a clear obstacle to sharing more data for research, for example. But we're forgetting that data sharing and using data is most importantly a matter of business strategies and money available in the economy to create those business models, which were very much lacking in Europe. And no legal system will solve that once and for all, and certainly not a legal system that adds more rules on top of the rules that we already have.
Thank you very much, Alberto.
Inspiring.
How to put it? Your first reaction is very natural, because most of the time, and for very good reasons, I may admit, scholars and academia tend to focus on misuses, overuses, rather than underuses, for a simple reason: underuse is invisible. And so either you are ready to notice what's invisible, or your first reaction is, what's this all about? Mind, the European Parliament has stressed this problem in a famous press release rather than a resolution in 2020. And when you were stressing the fact that, well, maybe it's more a matter of non-personal data than data, we have a couple of options, an alternative here. That is, some scholars, that's not my position, but come on, all data is personal data at the end of the day. Since I'm working a lot on outer space, I would admit that in some cases data about Venus and other planets is still not personal data. On the other hand, this is a very sectorial issue. That is, I think that the problem depends on the specific sector we are dealing with. I already mentioned medicine and healthcare. Here is a hidden tragedy. And if I think, I told you, the GDPR has triggered, for obvious political reasons, the compromise which allowed the GDPR in 2016. Well, if I think about what's going on, for example, with the Italian regulator in the health sector, considering the reuses of personal data for scientific purposes, well, I don't want to say this is a tragedy, but this is a hidden tragedy. On the other hand, another example could be public administrations. We already mentioned several EU acts and even normative sagas. I may add the public sector information saga, starting in the 2000s, then 220s, and so on and so forth. But since you were really good in respecting times, but we have maybe some time for a first round of a reaction, if starting with Bárbara, and then of course we're going to have the questions and answers time. Please, Bárbara.
Yeah, I think I agree with you. I think we are, this one? Yeah.
Yes, it works.
I think we are summing up a lot of acts and regulations on top of regulations, which bring more questions than answers to us. on your comments on the Data Act and what is personal or non-personal data. I made a recent analysis on that, and instead of answering that question, they are applying now the same rules of personal data to non-personal data. So they cannot solve the problem. So let's extend the same rules to everything. Maybe that's solving the problem. I don't know. Also, maybe a solution for the underuse, besides being different, like tackling the problem depending of the sector that you're talking about. So education, health, data, it's not summing up more and more regulations, but creating like nuanced approach that it's with the public sector and with the private sector, because we need to develop an economic system that pushes for, let's say, unleashing the the potentials of data silos that are hidden somewhere in a cloud. But I think if you think about putting more regulations on top of regulations, this won't solve the problem, because we know so far it didn't. So just throwing these questions.
Well, thinking about what's going on with the Artificial Intelligence Act, good luck. And Aurelie or Antonius, and then back to Alberto if he wishes to add some further words.
Thank you. No, very interesting thoughts. Just two reflections. First, I think what we see in terms of new legislation that is particularly useful is legislation that is not entirely new, such as unlinked with existing legislation, but building on bricks of the GDPR. What do I mean? For example, in the GDPR, there are a lot of so-called opening clauses, usually for member states, to establish legal basis for certain types of processing of personal data. For example, one of the grounds of lawful processing is carrying out a mission in the public interest, but it doesn't work on its own. The member state needs to legislate something about that, to assign a mission in the public interest. And what we do see is that there is legislation at union level, because of course member states are one possibility of creating that legal basis, but union law is also another possibility. And I can think two examples that I find particularly useful. They're both pending legislation, so we don't know yet how they will be shaped in their final form, but the proposal has been made and it's now pending between the two legislators, European Parliament and Council. One of them is the European Health Data Space, and there the idea is to build on Article 9, Paragraph 2 of the GDPR, because as you know, health data is a special category of personal data that I always find a very long term. I prefer to say sensitive personal data. It's shorter, but okay, the official term is special category of personal data. So it's in principle prohibited to process it. You don't need only to comply with the ground, with one at least ground of Article 6, Paragraph 1 of the GDPR, but in addition to fall under one of the exceptions of Paragraph 2 of Article 9. And in practice, all of those, except some exceptional ones, they need a law, member state law or union law. And in the field of, for an important public health objective, this can be done at union level, and the idea is to create data spaces that this use of health data will be more facilitated with appropriate safeguards and everything, because when we have these possibilities at member state level, we see that some member states use it. We have such data spaces in Finland, in France, we have initiatives, but for the majority of EU member states, there is simply nothing. And at union level, when you legislate that, you create one such possibility. The second example is the directive for platform workers. It concerns another kind of opening clause in Article 88 of the GDPR, which is about special rules that member states can legislate for data protection of workers, to have even more data protection than usually under the GDPR. And considering that platform workers is the workers of Uber, of such platforms, they need, normally they're a vulnerable part of the working population. There is a directive in order to build on that, and instead of having individual member state laws or no laws at all on that issue, there will be a directive instructing member states how to create some common safeguards. That I find useful because it builds on a consistent ground of the GDPR, and the branches develop on that consistent ground. And second reflection is about the notion of personal data. It can be very wide indeed. And what we see, and it's interesting in recent case law, is that there is some relativization, if I may call it, of the concept of personal data. So something may be personal data for one person, for a controller, but it may not be personal data for another entity. Another, well, it's not a controller because it's not personal data in such a case, but another holder of that data. And this one can already see the origins of that from the Breyer case law that said about some access to data being illegal, then it's not possible for that entity to really consider that they can access that as personal data. But we see it much more emphasized in recent case law, particularly at general court level. I have in mind two judgments of the General Court. One is recent on the Single Resolution Board. The other one is about a press release of Olaf about a certain fraud issue. And there was, I will not say more because the allegation was precisely that because of an anonymous press release, there was a possibility to identify the fraudster because of a certain journalist that had knowledge of the family and of the situation that you wouldn't expect otherwise. And the General Court said, well, but that was unexpected, this knowledge of the specific journalist. Of course, this is pending on appeal in the Court of Justice, so it will be interesting to see what the Court of Justice thinks about this concept. And there is also an Advocate General opinion on vehicle identification numbers and whether they constitute personal data. And the Advocate General, so far, we wait to see the judgment of the court. It's still pending, but the Advocate General takes the view that there can be cases where this is personal data, because if, as for example, as a public authority, you know this number and you know the names of individuals because of their matriculation certificates. Similarly, the braking data, one can think, well, if you are a manufacturer and you have braking data to improve a service and you also have the names of your customers concerning that braking data, maybe as weird as it is personal data and you know who brakes in what way. It's a bit like a fingerprint, but maybe not for the average individual on the street. That's an interesting concept, and it would be interesting to see how it's followed up, especially at Court of Justice level, whether it will be endorsed or to what extent. Thank you.
Thank you very much, Antonio. Aurelie? Do you want to? Sorry.
Thank you. Yeah, maybe just a short one. I also have the feeling that legislation in Europe is building up. I didn't compare it to a tree, but more like La Sagrada Familia in Barcelona. And so I try to keep faith in what policymakers and lawyers are doing to make sure that this goes in the right direction and we have less uncertainty in business in general. However, and I'm sorry to be coming back to the same issue, is it's nice it's branching out, but there is still a big disconnect between what technology does and what the law is trying to do. And so we've seen schemes in terms of self-regulation. We are seeing top-down rules and potentially sometimes guidelines. I would just wish that potentially the EDPB, the supervisory authorities, maybe sectorial associations, we could start thinking in terms of more specific support for businesses, in terms of best practices. As a data protection officer, I feel terribly lonely, so I'm always very happy to be here at CPDP and exchange with people. But this is really clearly missing, because when you think about it also in the end, all these conversations about privacy engineering, about uses of data, about consequences on society are the most interesting engineering challenges we have. And it really should be about collaboration, co-creation, and in order to move forward.
Thank you, really. I love your image of EU law as a Gothic law. Maybe we should look for Batman. And Alberto, please.
No, I'm just reassured by Antonius's wonderful illustration of recent case law that will need to be confirmed. But I think that's very reassuring for me because it shows that it is possible to work around these issues and possibly what we have been doing so far, including regulators. I mentioned the EDPP guidelines. I guess the court is being a lot more granular and I would say much more sided with the way that we would interpret as industry these discussions about personal, not personal than regulators. So that's encouraging, but it also shows that I think we're getting ourselves, to go back to my previous point, we're getting ourselves into a new can of worms because there will be much more of this interpretation to do. As the concept of personal, non-personal, and what you can do with it, and by and in relation to that, what rules are applicable, we'll go into those discussions again and again with this concept of data sharing, getting more people in there. For some people, it may be personal. Some others, it may be not personal. What is the relationship of the user/data subject with the new uses of data? And let's see, I think we'll have a few interesting years ahead where we'll see possible actual uses and businesses growing, and then ultimately going all the way to the court. And we'll have a lot of trips to Luxembourg to figure out whether it's working or not.
Thank you very much. Please, questions? I don't know how it works. If or there is the mic. It doesn't work. Well, I have a. Come on. It's going to be easier this way.
Hi, Baron Soga, Tech Freedom. Thank you, Alberto, for asking the question you did. Is the issue really personal data, or is it other forms of non-personal data? So I was expecting more of a discussion of pseudonymization and de-identification. I mean, that seems to me to be the real trade-off. I can't speak to the data here in Europe, but in the US, there is a live debate on exactly this topic, and there is clear evidence that there's underuse of those forms of data, and that there are real costs to drawing the line too conservatively. And some of the famous examples include health data, and there's real evidence that tens of thousands of people have died because drugs, for example, have been allowed to stay on the market that were killing people. And that could have been detected earlier if our agencies had been allowed to use larger data sets of pseudonymized data. So I was expecting more of a discussion of those trade-offs. I'd love to hear the panel's thoughts about how that line is being drawn, and not just how it's drawn in theory, but how it's drawn in practice. In particular, if you're a privacy officer at a company and you're advising how to draw that line, and you're considering the risks of not just fines, but reputational costs to your company, are you drawing the line smartly? And do we need to adjust policy to make sure that we're actually encouraging the use of data for beneficial purposes when it's possible to do so by, for example, just requiring that the data not be reassociated with other elements that could tie it to an individual?
Excellent point. Maybe we can collect another question and then, but please.
Thank you for your contributions. My name is Aditya. I'm a PhD researcher at the University of Edinburgh. I wanted to touch on something that I think Alberto mentioned about whether the problem or the impediment is not legal, but question of incentives and business models, because I think my question is, when it comes to personal data, while I think health data is, I think, an obvious and important use case for reuse, I sometimes wonder if we're making some assumptions about the sort of usefulness and the sort of fungibility of personal data and the sort of potential use cases for reuse, because I think of ad tech, for example, as the sort of instance or use case where there is a unending appetite for personal data, like where more and more personal data is better and always better because it helps you personalize in ways that are more targeted. And I guess my question is, are we making that assumption? And obviously that is a large part of why many of the conversations around data protection exist in the way that they do. So I'm wondering if we're kind of making that assumption, that assumption applies to other contexts where you don't have that unending appetite for data.
Thank you very much. Two excellent questions. So if please, Alberto.
Yeah, they are indeed excellent questions. For the first one, I think, I mean, the issue of the safeguards around the use and the role of the safeguards in generating more use in general is something that we tend not to look at. Most debates are very dramatically about the legal bases that people have to use data. So the first question you face as a company is, what is your legal basis? And there's obviously quite a lot of focus on consent, because consent is good, consent empowers people. And actually, I, as a user, find that consent is very useful for some things, but I don't want to be bothered and asked all the time. There are some things and some data of mine that should be processed logically, because I'm doing things, I'm requesting things. There's very unexplored potential of contract as a legal basis. We mentioned the impact of legislation. There's a very, if you will, still unexplored and limited reading of what legal obligation means. Obviously, there's legitimate interest. Legitimate interest is very important because precisely the safeguards, anonymization and other things are exactly what makes legitimate interest more palatable. The more safeguards you put in place, the more likely, the likelier it is that you can use a legitimate interest as a legitimate way to use data without bothering people, without going back to the people that the data belongs to for nefarious purposes. And all these things are very, very unexplored. If anything, there's this, witch hunt against legitimate interest. So I don't think this is working in our favor. Here again, I look at the court largely because this is, I think, an area where the court has been very helpful. You mentioned the Breyer case, Antonios. The Breyer case is, very well known because it established that dynamic IP addresses can be personal data. Wonderful. Everybody forgets the second part of the ruling, which is, okay, that's personal data, but there was a legal basis because it was in the legitimate interest of the data controllers to collect that traffic data for security of the services that were being provided. So very important to remember that second part. And again, we should have many more discussions about these elements, which I think ultimately we tend to forget. I mean, a lot of the business difficulties when it comes to legal compliance really stem from the GDPR. We tend to forget that so far, data processing at large, contractual relationships, business relationships am I respecting the GDPR as the first question of whether this is legally viable? So if we can look at these issues and solve GDPR matters, it becomes less important to look at more legislation and possibly needing to solve things through that, even though there are areas where new legislation is absolutely necessary, healthcare being one of them, absolutely. The second question, and by now, again, my mind is very limited. I must have forgotten most of your your second question.
Well, but
Just
let's see
ping me.
if.
Go ahead.
I'm also happy to address the
Please,
first
Aurelie.
question. Thank you, and I'll pass it on afterwards. Again, from a very pragmatic point of view, as the gentleman talked about pseudonymous data and health data in the United States. What I'm seeing is certainly a kind of obsession with fear of risk under HIPAA, while at the same time, PHI under HIPAA is very different from personal data under the GDPR. And so increased requests to sign BAAs, but the obligations of the actors do not only relate to the fact that you need a lawful basis on GDPR and things like that, or consent, however you feel about it, but it's also a lot of security measures that go around it. So the notion of risk, certainly for sensitive data, let's call it sensitive data for the US, is very, very different also under common law and class actions. So comparing this idea of pseudonymous underuse, yes or no, between, and certainly in that specific use case, is very different in terms of risk for the United States and Europe, at least in my opinion.
Thank you. I know, indeed, some thoughts as well on anonymization versus pseudonymization. It's a very fundamental difference in the sense that when you anonymize something, it's no longer personal data legally. In terms of data protection law, at least, you can do anything you want with it. I'm not speaking for other fields of law, but pseudonymous data is still personal data, and it's also difficult to see where you cross the line sometimes, how much complexity has been put into a pseudonymization that it makes it irreversible, reasonably speaking, to go back to the initial personal data. It can be difficult to see where you cross the threshold, and also it can be hard to anonymize certain data erga omnes towards anybody in the world. I was reading once the guidelines of the EDPB on anonymous data, and I think they date back from the Article 29 group. You would see examples that you would think, but this is anonymized data, this cannot be reversed, and they give you the way with high IT tools that it can be reversed. Now again, the concept of relativization can be useful because maybe those tools are not in the hands of everyone, but to be seen what the case law of the court will say on that, of the Court of Justice, most importantly. Pseudonymization, on the other hand, doesn't mean that we don't have personal data. We still have personal data, but it can be a useful safeguard. But again, it's not a useful safeguard for every purpose in the world. We need to think what it is a useful safeguard about. For example, in terms of security, it's useful. It gives some additional layer of security. If some data is leaked without the key to reverse the pseudonymization, it's useful. But it doesn't mean that once you pseudonymize data, you can do anything you want with it. And then on legitimate interest, indeed, can be an important ground for lawful processing. There, I think, in terms of pragmatic terms of what to look for, we need to see what the data subject reasonably expects, because that's a key test for me. It's a legitimate interest when it is expected by the individual reasonably that this data will be used for this purpose. If I ask your email addresses to send you the case numbers of some cases I mentioned, good, you agree to that. But if I start then spamming you about irrelevant stuff, or I send those email addresses to some bookstores that sell books on personal data because I tell them, look, there is a group that is interested, these are reasonably not expected uses that wouldn't be covered. And we have on that also a very interesting case coming from the Netherlands, pending on preliminary ruling, pending before the Court of Justice, on the notion of legitimate interest and whether to what extent economic considerations can count as legitimate interest. That is an interesting one to follow up as well.
Of course.
Can I answer the second question? Because the second, you remember? I think the idea that we all talked about during the panel and was included by the first question is that we cannot put all the underuse, the appetite for data use and underuse in the same bucket. I think we cannot compare the use of Facebook, whatever, with health data, for example. I think they are for different purposes. So we have been defending here is that the risk of underuse is basically context dependent. So of course there's the risk of underuse or the risk of in health data purposes, for example, as they defended in the first question, is way bigger than in ad, for example, in Facebook or Instagram. You know what I mean? Like, I think the life of people are more impacted if you don't use health data, if you use my scroll data to show me pictures of cats in Instagram. So I think this is the main point that we need to highlight here. Yeah.
Yeah, and just because you also reminded me about the second question, indeed, we are assuming a lot, and the use of data doesn't start from the abundance of data necessarily. It starts from the use case. So, like Uber didn't start because Uber had started to collect data left, right, and center. Uber had an idea for people wanting to move and drivers, two-sided markets. They put them together, and of course, they're using a lot of data now, but it comes from the service. It's improving that service. I would argue that improving that service is clearly a legitimate interest of that company. So an economic interest definitely is, and I hope that the court will confirm that definitively. But again, it didn't start from the hordes of data that are out there that are non-rivalrous. It started from the use case. And we're, again, by overstressing the amount of data out there, we're not focusing on, again, the business development side of things. What is the use case? And what are the conditions to create that use case? And data will be one of them, most likely.
Final quick, because in 10 minutes it's going to start the other panel. So, Claudio, please. Thank you very much, Hugo. My name is Claudio Lucena. I'm a member of the National Data Protection Council in Brazil. Thank you very much for your remarks, very insightful, and thank you, Hugo and Massimo, also friends from the University of Turin. It's not the first time we're drawn to one of your panels by its insightful and interesting titles and text and everything. I would like to explore with you, I've seen we've touched upon European institutions as drivers of these issues. I would like to explore a bit to you the role of data protection authorities, because it seems to me that, and within the context and in the contact with the various data protection authorities throughout the world, we see that lack or shortage of work power is always there. So in a world where the underuse, where the misuse or the overuse is the role, it seems data protection authorities are considering in what cannot be done with the data. So it seems also to me that it's also their role to understand and incentivize the correct and adequate use of data. We concentrated on the institutions. I would like to hear from you about the data protection authorities as well. Thank you. Thank you very much. And we have to finish in 3 minutes, so.
Can I try and go? It's very important, and I think they need to engage. We see sometimes, a lot of criticism because some of them relate to the big cases, but certainly, like, take the Irish Data Protection Authority. You can argue that they have heavily engaged with their constituency to find solutions, and we'll see if the solutions, are faced with good judgment from ultimately from the courts. But we've seen too often examples of data protection authorities going in the opposite direction and really being not helpful and taking very absolutistic views. One example that I can give you is companies wanting to anonymize data to do new things. We've had those discussions in Germany, for example, and the result is that the data protection authority in the German land will come back to you and will tell you, well, you can't just anonymize data. You need to have a legal basis and a reason to anonymize data. Otherwise, I'll fine you. So this is an example of it not being very helpful, because these are exactly the types of solutions that should be encouraged. And this is not even pseudonymization. This is people who wanted to genuinely try to anonymize the data. And it was, their question was not so much, how are you going to do that? Is it genuinely going to be anonymous? Their first reaction was, you need to have a legal basis to anonymize data.
Of course, Aurelie.
Thank you. There was a call this week also at CPDP about the fact that data protection authorities, supervisory authorities don't share enough about the cases. So yeah, we hear about when they go to the European Court of Justice, and there's people like Herke that sum it up, and it's great, so we can actually follow, because there's a lot out there. I would, however, challenge your position, and I do understand sometimes supervisory authorities are not helpful at all. And I think it's improving. Honestly, it's getting better, and the collaboration is getting better as well. I would tend to challenge and ask you, is it their role to actually push for more uses? I think that their role is to protect data protection.
Okay, but underuse is costing human lives.
True.
Well, their role is to facilitate compliance.
Okay.
Compliant use, as well as to protect when there's non-compliant use.
There's another step to say their role is to go further and push for further use of data. So it's like, so.
Just to add that with the Data Act, with the Data Governance Act, they are adding more responsibilities to the DPA to comply. So I think they are going to be mixing up the roles of the DPAs with other besides GDPR.
But actually, what is a problem, and that's the end, we need a change of mentality in public authorities because this problem is costing human lives, as it was stressed before in the health sector, but not only in the health sector. Let me thank you, our panelists, and thank you very much for our attendance, and it was a pleasure.